Hello everyone. Am I audible to everyone? Am I audible?
Yes, sir.
So today we are going to discuss what are the major changes has been made under the Code of Criminal Procedure 1973. And with this regard, after a complex meeting and after the detailed research upon the Criminal Procedure Code, finally we have the Bharatiya Nagarik Suraksha Samhita 2023, in which major changes have been found, and mostly the provisions relating to the arrest, attachment of the property, and all things have remained being same. But some of the provisions, approximately 10% of the provision, either have been substituted or have been made amended, or they have been changed in their severity of the punishments or the procedures. So we are here to discuss what major changes have been made in the Bharatiya Nagarik Suraksha Samhita. Though we all know that we had the Code of Criminal Procedure 1973. So we are going to discuss. So we have to discuss. Okay. So what changes have been made under the Code of Criminal Procedure? Therefore, we required the Bharatiya Nagarik Suraksha Samhita. We are not going to the timeline and implementation. We have to come to the objective of the Bharatiya Nagarik Suraksha Samhita 2023. What is the objective? The Bharatiya Nagarik Suraksha Samhita 2023 is an act to consolidate. What to consolidate and amend the laws relating to the criminal procedure. It means the what rights or obligations or liabilities have been imposed under the Bharatiya Nyaya Samhita. There should be the procedure to be followed under the Bharatiya Nagarik Suraksha Samhita. Is it clear? In which the President has given the assent on 25th December 2023. And finally, it has been enforced on what date? 1st July 2024. When we come to the definition clause, the one section in the definition 2A provides audio video electronic means. What it means, whether we do not have in the Code of Criminal Procedure, what is the communication electronic means? Yes, we had, but it was not in that such manner which has been given in, and what powers have been given under the audio video electronic means to the police or the agencies. It has not been given under the Code of Criminal Procedure. Like audio video electronic means, it includes what it includes any communication for the purpose of video conferencing. Though the video conferencing was also introduced in many high courts, Supreme Court, and in this very basic term, audio video conferencing, the Honorable Supreme Court in one of the leading judgment has been held that the audio video electronic means comes under the definition of section 327 of the CRPC, which means open court. Open court means the proceeding of the court shall be live streamed. It also comes under the Civil Procedure Code under section 153P. Is it clear? Please tell me. Then I will Go ahead. Okay.
Yes, sir.
Now we have to come to the another definition which has been made: electronic communication. Now in the last we have audio video electronic means. Here is the means of the what is the audio, what is video, but how to communicate with the electronics. So how we can communicate? By written, verbal, pictorial information, video content transmitted or transferred. Is it clear? By either by telephone, by mobile phone, by computer, by audio video player, by camera, by any other electronic devices, or any laws or notification made by the central government. This is the new definition has been given under the BNSS. Also, there are two definitions: bail and bail bond. The word bail has not been defined. Bail bond has not been defined in the CRPC, but here it has been defined. Bail means when the person has to be released by furnishing a security, that is bail. Or bail bond, when he will be released on a bail with sureties. There is a distinction between the sureties and the security. Is it clear? So hierarchy of the courts, you all knows that. Which is the highest criminal appellate court in India? Tell me. Tell me, student. Anyone? Which is the highest criminal appellate court? Anyone? Supreme Court of India. Then High Court. Then Session Judge. Assistant Session Judge. Now the Assistant Session Judge has been removed from the hierarchy of the courts. And again, the Metropolitan Magistrate also been removed. Is it clear to you? Therefore, there is a section about the Metropolitan Magistrate. It has been removed. Establishment of the Directorate of Prosecution. It was there. It was there under Section 25A, which has been made under by the amendment of 2005 Criminal Law Amendment Act. It was there, but there has been given some scrutiny by the Directorate of the Prosecution. What kind of matter the Directorate of the Prosecution will scrutinize? What will be the matters? What kind of matters will be scrutinized by the Directorate of Prosecution, Deputy Directorate of the Prosecution, Assistant Directorate of the Prosecution? So there are the list of the offences in which there shall be the Directorate of the Prosecution. Is it clear to everyone? Therefore, the Directorate of the Prosecution shall monitor the cases in which offences are punishable for 10 years or more, or with imprisonment of life, or with death, or to expedite the proceedings and to give the opinion on the filings of the appeals. So the state government or the central government shall consult with the Directorate of Prosecution on filing of the appeals in case of the matters which is punishable with the imprisonment of 10 years or more. Is it clear about the establishing a Directorate of Prosecution? What about the rest? In relation to the rest, what changes have been made? So, arrest has been basically given the power of the police to arrest any person who has committed an offense cognizable. The police can arrest without warrant any person. Okay? And the provisions relating to the arrest was given under the Code of Criminal Procedure under Section 41. It was the power basically given to the police. But now this section has been given the corresponding meaning in Section 35 of the Bharatiya Nagrik Suraksha Sanhita, which consolidate two more sections, 41A and 41B. So I would suggest something to you what you have to be refer while you are reading out the meanings of the arrest, what is the arrest, what who can make an arrest, whether private person can make an arrest, whether magistrate can make an arrest. But there is no change, but there is only one change relating to the arrest by the police, where an arrest, where an offense punishable less than 3 years and the person is infirm or above the age of 60 years, an arrest can only be made by the district superintendent of the police. Is it clear? An arrest has to be made by the either by the DSP or with the permission of the DSP. An inspector can also make such arrest. This is the provision which has been amended under the BNSS. Okay. If private person under section 43 of the Code of Criminal Procedure, if any private person make an arrest, there was no necessary limit. There was no fixed limit when he has to be produced before the court, when he has to be produced before the police officer. Now it has been fixed. If any private person has made an arrest, it is a person has to be produced before the police officer within the time limit of 6 hours. Kindly underline 6 hours. Clear? Next, arrest homemade. So, firstly, when we talked about section 46 of the Code of Criminal Procedure, there was a simple provision. An arrest can be made by uttering the words. By uttering the words, an arrest can be made. But now, in the serious offenses, an arrest has to be made by handcuffing. How they have to be made? By handcuffing. What kind of offenses? There are certain provisions which has been mentioned under the arrest. What are these? Repeated offenders, organized crime offenders who has committed an offense of the organized crime, terrorist act, and drugs related crime, or illegal possession of the arms and ammunition, murder, rape, and acid attack, counterfeit coins, currency note, human trafficking, sexual offenses against the children, etc. They have to be handcuffed. Is it clear? Please tell me. You must have to
Yes,
take
sir.
tuition.
So, I have a question.
Yes.
So, what is the definition of private person in section 40 of BNSS?
Private private person means any person. Any person. Any person can make an arrest if non-bailable, cognizable offense have been committed in presence of the private person, or where an accused person is a proclaimed offender. The private person can make the arrest of such person. Private person means if in presence of you and me, any offense has been committed, the person shall have the right to arrest such person. And within a 6 hours, he has to be produced before the police officer. Is it clear? It has to be hand over to the police officer. Clear?
Yes, sir.
Yes, please. Whether PPT is showing to you?
Yes, sir, it is visible.
Yes. So, arrest of the woman, there is a same provision. No woman shall be arrested after sunset before sunrise. This is the cardinal principle of the criminal. No woman shall be arrested after the sunset before the sunrise. But in exceptional circumstances, she can be arrested. She can be arrested only with the prior permission of the magistrate. That is judicial magistrate first class. Next, medical examination. Under section 53, 53A, 54, there was a principle relating to the medical examination of an accused, of an arrested person. There was a limit has been given to the police. But under the Bharatiya Nagrik Suraksha Sanhita, the rights of the police officer has been spread, has been given the more power that on the request of the police officer, any medical officer who is registered medical practitioner, who is registered medical practitioner on his request, there may be the medical examination of the arrested person or accused person. Next, forward. Yes, this is the main, this was the basic principle which has been argued many times. This was argued many times. What about the proclaimed person who has been proclaimed, who has been declared a proclaimed person, who has been declared proclaimed offender by the court? What about the relation of these properties, whether these properties has to be attached, whether the properties of the proclaimed person when it is to be attached, whether in the sense of the proclaimed person there can be the inquiry, investigation, or the trial. The CRPC did not contain such provision. But under the Bharatiya Nagrik Suraksha Sanhita, there is a provision relating to the identification and arrest of the property of proclaimed person. Is it clear to you? Now there is a provision. Now this is the principle which is being mentioned. If any person has been absconded from India and he is not coming, like Vijay Mallya, he is not coming to India, and we did not have any provision relating to the attachment and confiscation of the property, then what we have to do? We need such law under which the property can be attached. So finally we have Bharatiya Nagrik Suraksha Sanhita, by which a property can be attached. Is it clear? Yeah, there is also the line which I have used. The intention behind the provision seems to either to secure the presence of the fugitive or the confiscate properties of the fugitive who are evading the summons, investigation, trial, or have the properties outside the country. Okay. Next. And this is not only about the provisions relating to the investigation inquiry, but now the provisions relating to the property of the proclaimed person, proclaimed offender. He may be tried by the court of competent jurisdiction. Under section 356, it has been newly added under the Bharatiya Nagrik Suraksha Sanhita. It will be presumed as trial at absentia. It means in the absence of the proclaimed person, proclaimed offender, a trial may be done. Okay, clear? So is it clear to you relating to the property investigation, trial, and investigation, inquiry, and trial of the property relating relating to the proclaimed person or the proclaimed offender, how the inquiry has to be done, how the investigation has to be done, how the property can be attached, what are the provisions under section 356. There is a detailed provisions relating to the attachment of the property, relating to the in trial of the absconded person or proclaimed person. Yes. Any question?
Sir, can you explain section 356 once again in some details?
Yes, section 356. If you will go through the section 356, there is a provision relating to the trial. Trial in absentia. Absentia means in absence of the proclaimed person, there may be the trial. There may be the trial of the person who has been absconded or who is a proclaimed offender. Is it clear? The person who is a proclaimed offender, now the Bharatiya Nagrik Suraksha Sanhita has a provision relating to when any person who has been absconded, who has been declared as proclaimed person, proclaimed offender, whose property under the supervision of the government can attach such property under the trial by the court under section 356. And there is a provision relating to that not below the 90 days after framing of the charge. There is some provisions. Is it clear? Now come to the next topic and next point. So this is additional power to the attachment and the forfeiture of the property. This was also the basic principle which has been given under section 105 of the Code of Criminal Procedure. Under 105, the magistrate has power to attach the property identified as a proceeds of the crime. This is the new term which is being used. Proceeds of the crime. What is the proceeds of the crime? The proceeds of the crime has been given, which is being taken either by committing an offense. And the definition of the proceeds of the crime has been given under section 111 of the Bharatiya Nagrik Suraksha Sanhita. Is it clear? Where any person who has taken or obtained a property by means of the crime, these properties shall be known as the proceeds of the crime, which means the person who obtained the property does not have to right to obtain. It means it is an illegal possession upon the property, either by committing a crime or illegally possess the property. Clear? Next. And what about the seizure of the immovable property? When we talked about section 102 of the Code of Criminal Procedure, if you will find a section 102, which means seizure of the property, where the specific word has been mentioned by the Honorable Supreme Court in Naveda Properties Limited case, in which Honorable Supreme Court has held that when the police searching any place, the police can only attach movable properties. It means seizure includes only movable properties under the Code of Criminal Procedure. But now it does not only restrict with the movable property, it may also include immovable property. That's why BNSS broadens the scope of the CRPC's police power to property seizure, while CRPC initially allowed the seizure of movable properties. Is it clear?
Sir, in which section is this provision mentioned?
In which section? Section, there may be the section 99 or 98. BNSS. Okay? I'm telling you what section. Yes. section 106, section 106 of the Bharatiya Nagrik Suraksha Sanhita. Next, power to remove obstruction by the police officer. Power to remove obstruction. So, if you will read section 149 of the Code of Criminal Procedure, where any person who intended to commit any cognizable offense, the police shall prevent such person of committing such an offense. Therefore, section 172 has been inserted under the Bharatiya Nagrik Suraksha Sanhita, in which the provision states that which casts an obligation on the persons to conform to the lawful directions of the police officer in the fulfillment of any of his duty under the relevant chapter pertaining to the preventive action of the police. It means where any person has been directed by the police officer to prevent a crime, he is bound to prevent. Is it clear? And again, the police officer may either present such person before a magistrate or in petty cases release him within 24 hours. If any person has committed a petty offense which has been mentioned under section 206 of the Code of Criminal Procedure, and now it has been given under section, it has been mentioned under section 200, 215 or 216, etc. Where any person has committed an offense which is of petty nature, if such person is before the police officer shall release such person within 24 hours. Is it clear? Now, so finally we come to the power of the police officer. The procedure for investigation, lodging of an FIR. Firstly, I have to clear you and I have to state very clearly the word FIR has not been mentioned under the Code of Criminal Procedure, and now in the Bharatiya Nagrik Suraksha Sanhita, it has not been defined. Therefore, the concept of zero FIR is not new in the Bharatiya Nagrik Suraksha Sanhita. It is not new, but it has been taken from the direction given in the Lalita Kumari case versus State of UP by the Honorable Supreme Court. The Honorable Supreme Court has stated that where any person has committed a cognizable offense or any information relating to the cognizable offense has been given to the police officer, such police officer is bound. What bound? The police officer is bound to lodge an FIR. First, information report, irrespective of the jurisdiction. It means the police officer is now bound whether he has a jurisdiction to conduct an investigation or not. He is bound to lodge an FIR. Therefore, the direction of the Lalita Kumari case has been incorporated under section 173 of the Bharatiya Nagrik Suraksha Sanhita as zero FIR, irrespective of the place. If you have the barrack, you can see. If you have the barrack with you, you can see. There is a provision. Do you have a barrack with you?
Yes, sir.
You can see. There is a provision. And under section 173, there was no concept of the preliminary inquiries relating to the sentence. If there is an offense punishable with 5, 4, 3 years or any of the offense, there was not mentioned in the Code of Criminal Procedure that the preliminary inquiry has to be conducted by the police officer. There was not required. It was not required. But Now it has been mentioned under the Bharatiya Nagrik Suraksha Sanhita, if an offense punishable with the imprisonment less than 7 years, the officer in charge may conduct a preliminary inquiry. Preliminary inquiry may be conducted by officer in charge with the prior permission of deputy superintendent of the police officer, and the report of the preliminary inquiry has to be made within 14 days. Is it clear? If there is a prima facie case, either it is been a case which is punishable with less than 7 years, then the police is bound to register an FIR. Is it clear? The provision relating to the FIR. This is the case Lalita Kumari versus State of Uttar Pradesh. Clear? Now, under section 155 of the CRPC, that is the report information relating to the non-cognizable offenses. Here it has been mentioned under section 174 clause 1 of the Bharatiya Nagrik Suraksha Sanhita, which has been augmented by the introducing the time period of the fortnight for the police officer to forward a daily diary report to the magistrate. It means the fortnight after lodging a non-cognizable report under section 174 by the police officer, it has to be produced a report before the magistrate. Clear? And the power of the police officer shall be the same to investigate what it has in case of cognizable offenses. So there is no change relating to the cognizable offenses. Clear? Now, report of the police officer on the completion of the investigation. Yes. On the completion of when the FIR has been lodged, there is a statement of the either of the person who is acquainted with the facts, or the person or the accused or any other person. Then in such circumstances, the police, after the examination of the witnesses or the person acquainted with the facts, it has to make a report to the magistrate who has a power to take a cognizance in such case under section 210 of the Bharatiya Nagrik Suraksha Sanhita. So, under section 193 of the Bharatiya Nagrik Suraksha Sanhita, it is an obligation on the police to inform the victim or to informant about the progress. What progress? It means when the first FIR or NCR has been lodged under section 173 and 174, either FIR has been lodged or NCR has been lodged, then the police has to make a report to the magistrate. Within how many days? There is no limit. But the progress report of investigation, including the electronic communication within the period of 90 days, has to be made to the victim. It is the duty of the police officer to make the progress report to victim. Further, the BNSS also permit the further investigation after charge sheet has been submitted to the magistrate. Note below the now requires that such further investigation shall be completed within 90 days. Under section 193 clause 9, there is a provision relating to the further investigation. Supplementary charge sheet. If any of the fact has been arises in the case, or any of the witnesses has been left which has not been examined by the police officer, which has, and who is agrees to give an evidence against against an accused person, the police officer shall take such a statement and may produce before the court. But such investigation has to be completed within the period of 90 days. That is further investigation. Now, sanction for the prosecution against the public servant under section 197 of the CRPC. If the public servant has committed an offense, the court shall not, no court shall take the cognizance except with the prior permission of the central government. It means the prior permission of the central government is necessary. Therefore, in the Manmohan Singh case, the Supreme Court has held that if the central government has not given the prior sanction within the period of the 3 months, the court shall presume the consent has been given. Therefore, now it has been incorporated under section 218, which provides that if the prosecution of the judges or the public servant, the grant by the central government or the state government has to be given within the period of 120 days. Is it clear? Now, committal to the session court.
Sir, I'm not clear with the previous section, sir.
Yes, previous section
Section
talks.
218.
Yes. Previous section talks about the prosecution of the judges or the public servant. Where any offense has been committed by the judge or the public servant and judge shall not ordinarily be tried by the court. Only on the mere complaint. First, the court in which the prosecution has to be started, the court has to take the prior permission of the central government or the state government in which the person is employed. There was no time limit, specific time limit under the Code of Criminal Procedure under section 197, but now it is a specified time limit. It is a specified time limit of 120 days. Within 120 days, the government shall sanction about, give the permission to try such public servant or judge. Clear?
Yes, sir.
Now, again, committal to the session court in case of the offense which are triable exclusively by the court of session. The magistrate, after taking the cognizance or examining the witnesses, shall commit the case to the court of session. Where an offense punishable with 7 years or more, the magistrate shall not try such case. Such case shall be tried by the court of session. Where such offense has to be tried by the court of session, the magistrate shall, after taking the cognizance or examination of the witnesses, it shall forward an accused to the court of session. Clear? And magistrate under section 209 of the CRPC, corresponding section 232 of the BNSS, stipulate the time period of 90 days. Within 90 days, which may be extended to the period of 180 days. But for the exercising the maximum limit, the magistrate has to write a reason why he has delayed from committing a case to the court of session. Clear?
Sir, what is the difference between a magistrate court and a sessions court in terms of hierarchy?
In terms of the hierarchy, the Supreme Court is the highest criminal court. It is also the constitutional court, Supreme Court, High Court, then Court of Session, then Magistrate Court. Magistrate Court can only punish according to the provisions laid down under Section 23. The court chief judicial magistrate shall have the power to punish any person who has committed an offense maximum 7 years. Maximum 7 years. Judicial magistrate 3 years. Judicial magistrate second class 1 year. Therefore, where an offense punishable with 7 years or more, the magistrate shall commit means forward such accused person to the court of session. And court of session shall have the power to impose any of the sentence provided by the law, including the death sentence. Is it clear?
Yes, sir.
Yes. Now let's move on. Framing of the charge. In the framing of the charge, or in the framing of the charge in the trial, there is not a significant change. There is not only a significant change, there is only a periodical change. In what, how many days a charge has to be framed, in how many days a discharge application has to be made, and how many days a charge in case of the magistrate trial it has to be framed. So there is only a periodical change. Periodical change has been made under the framing of the charge of powers of the court of session or magistrate. Therefore, you can see on your screen, there is a time limit of 60 days has been specified under section 251 under the Bharatiya Nagrik Suraksha Sanhita for the session judge from the date of the first hearing of the framing in writing a charge against the accused person. Is it clear? And after framing of the charge, after the argument, after the judgment, now there is also one stipulation has been made. One stipulation has been made under the powers of the session judge. The judgment has to be pronounced within 30 days after the conclusion of the hearing. How many days? 30 days, which may extend to 45 days. Is it clear? Is it clear? And finally, in also section 392, which talks about the judgment, judgment shall be pronounced within 30 days after the conclusion of the hearing. And the judgment, after passing of the judgment shall be uploaded within 7 days from the pronouncement. Is it clear? Within 7 days from the pronouncement, the judgment shall be uploaded on the website of the court. This is the new principle which has been mentioned under the Bharatiya Nagrik Suraksha Sanhita. Is it clear to you?
Yes, sir.
Now, discharge application, which has been also told you, discharge application within 60 days, the discharge application has to be made within 60 days. There is only the periodical change. There is no substantial change about the framing of the charge, that the charge shall be framed by the court of session or by the magistrate upon the complaint or upon the police report. There is the same provision. Only one change, that is periodical change. What about the discharge application? Discharge application has to be made to the court within 60 days. Clear? Summary trial. In the summary trial, there is some basic changes has been given under the summary trial. What is summary trial? Summary procedure of the offenses which are not very serious nature. Therefore, under the Suraksha Sanhita, it has been expressly mentioned where an offense which is punishable with 3 years or less, only such offenses can be tried summarily. Where an offense which is punishable more than 3 years cannot be tried summarily. This is the basic change being made under the summary trial. And there shall be no appeal from the judgment given by the magistrate in summary trial. Is it clear to you?
Sir, how it is different from a normal trial?
Yes, normal trial means petty offenses, which we earlier discussed. Petty offenses are those offenses which are not of the serious nature. Therefore, they have to be tried summarily. And like murder, rape, kidnapping, abduction, theft, these are the serious offenses. Robbery, gang rape, these are the serious offenses. These cannot be summarily tried because the punishment for the robbery, punishment for the docility, punishment for the kidnapping, abduction, rape, murder, the punishment is more than 3 years. When the offense is punishable more than 3 years, it cannot be tried summarily. Is it clear? Now I have to move on.
Yes, sir, clear.
Yes or no? Yes. This is the basic change relating to the digital signature. Digital signature. We had an act of the 2020 Criminal Identification Act 2022, where any person either arrested or not, the police may take the digital signature, digital impression, who is suspected person. Before that, only the digital impression, digital digital signature, digital finger impression, voice sample can taken of the convicted person under the Act of 1920. But now the digital signature, digital specimen impressions, and voice sample can be taken of the person who is arrested under Section 349. Is it clear? Now we have to move on. So I have to tell you each and everything in the very exhaustive manner. I'm not telling you in the very exhaustive manner, but I want you must have to be clear with every concept which is being changed, amended, or substituted, or added. Okay? Now, BNSS has sought to adopt the electric communication and video conferencing facilities at various stages, including investigation, inquiry, trial. It means now the investigation can be conducted by audio video conferencing. Inquiry can be conducted by audio video conferencing. Trial can be conducted by audio video conferencing. Examination of the witnesses or accused or any person who is acquainted with the facts can be done by the audio video electronic means. Is it clear to you? This was not provided in the Code of Criminal Procedure. Issuance of the process. Issuance of the process relating to the audio video. Before that, there was not e-summon, there was no e-warrant, there was no e-proclamation. Now there can be the e-summon, e-warrant, e-proclamation, e-summon, e-warrant, e-warrant. It means electronic summon, electronic warrant. Is it clear? And the witnesses can be examined. I earlier told this point. The examination of the witnesses can be done by audio video electronic means. Now please tell me, are you enjoying the class or not? Tell me.
Yes, sir, it is going fine.
Yes, because the audio video and the electronic means provided. Now, investigation. Yes. Under section 157 of the Code of Criminal Procedure, how the investigation has to be made, where any police report or information has been made to the police officer, he has to go to the scene of the crime and investigate the matter and make a report to the magistrate immediately. or have to depute. But investigation shall not be done in the two matters, where it is vexatious or there is insufficient ground. No investigation has to be conducted by the police officer. But here, the provision of the electronic means through the audio video electronic means have been made, and preferably by cell phone. Is it clear to you? An investigation can also be done by the audio video electronic means. Now, come to the next, production of the devices containing the digital evidence. Any devices under section 65B of the Indian Evidence Act. Under section 65B of the Indian Evidence, any digital evidence has to be produced originally by the first person user. It means if I'm using the laptop, I have to produce a laptop before the court. If it is suspected or containing any of the digital evidence. Therefore, there is a relevancy of the digital evidence. And now the devices, digital devices can be attached, can be seized by the police officer merely only on the suspicion of the either of the arrested person or even of the person who is not arrested. Also, it violates some principles of the right to privacy. But now it is not only violating the principle of right to privacy, but it is making the digital evidence as more significant, which is very necessary in conducting the trial or inquiry. I earlier told you, conduct of the proceeding through the electronic means, there is a provision. There is a now inserted the explanation section, audio video conferencing, issuance of the service of the summons, warrant, examination of the complainant, witness. I earlier told you. There is a provision. Okay? And there is also a forensic expert. Let's 1 minute. Is Kashif Bhai is there? Kashif sir?
Yes, sir.
Oh. Okay. So I'll have the CPC's class also, but we have to move on the Bharatiya Nagrik Suraksha Sanhita. Forensic expert report. Prior in the Code of Criminal Procedure, there was no forensic expert report. What has to be done by the forensic expert report? But now, where an offense punishable with 7 years or more, and a forensic expert has to investigate in the matter, and it shall collect all the evidence and document by using the electronic devices like mobile phone, etc. So offense punishable with 7 years or more. Okay. Now, under section 202 clause 1, it is a jurisdictional. In case of the cheating, prior there was no electronic cheating. No person can be electronically cheated under the Code of Criminal Procedure, but now the provision has been made under the Bharatiya Nagrik Suraksha Sanhita, in which it has been given the court under which an offense of the cheating by the electronic communication has been done. The court has the local jurisdiction such electronically communications or letters or messages where it is sent or where it was received has been empowered to try such offenses. Okay. Next, move on. Custody of an accused. There is also a minimal change in the Code of Criminal Procedure under Section 165. There was a provision relating to the remand, in which where any person has been arrested by the police officer, he has to be produced within 24 hours before the magistrate who is empowered to take a cognizance under Section 57 of the Code of Criminal Procedure. But such person may be produced after the remand, after the production of the person to the magistrate, may also be remanded to the police after such production. And there is only the 15 days, initially 15 days, under the Code of Criminal Procedure, a person can demand for the, a police can demand for the remand. But now it is not only been stuck to the initial 15 days, but initially 40 days or 60 days relating to the offense, where an offense punishable with 10 years or less. Initially 40 days, a police officer can seek the remand of the arrested person in the police custody. It will be maximum for 15 days, but initially 40 days, it can be by the police officer. Or in case of the offense where punishable with more than 10 years, or with punishable with imprisonment for life or death, then the remand in the police custody may be sought by the police officer initially 60 days. Okay, next move on. Bail and anticipatory bail. I told you earlier, relating to the bail, there is a provision relating to the bail and bail bond. Now under section 436 of the CRPC, under trial prisoner, if the maximum sentence and half of the maximum sentence has been passed by the under trial prisoner, he shall be released on the bail bond. But if he is an accused of the multiple offenses, now he shall not be released on bail. And there is also the provision relating to the anticipatory bail, which is been given under section 482 of the BNSS, and the section 1A and 1B has been deleted and omitted. And what about the special laws and the cases relating to the cognizance? There is the police officer, the magistrate can take a cognizance upon the complaint or upon the report of the police officer or suo moto. Is it clear? And the magistrate may also take the cognizance against the public servant arising in the course of discharge of his official duties, subject to the receiving of the report containing the facts and the circumstances of the incident from the officer superior to such public servant, after the consideration of the assertion made by the public servant. It means no public servant shall be arrested and no court shall take the cognizance against the public servant until and unless an assertion has been made by the superior public servant. Trial against the absconding person, which I earlier told you, relating to section 356. Now under section 356, there is a provision relating to the another significant change under the trial of the absconded person or the proclaimed offender or the proclaimed person, which I have earlier dictated you. And this is also the provision relating to the periodical change in the charge, trial, what up to what days the discharge application has to be made. There is a 60 days relating to the discharge application. And no, the new provision which under section 336 of the BNSS has been given, that is where the document or report prepared by the public servant or scientific expert or medical officer or investigating officer is purported to be used as an evidence in an inquiry, trial, or proceeding under this code, it has to be given, and such report may be taken in an evidence even such person is not present or he has been transferred. Is it clear? Now, witness protection scheme under section 4398 of the Bharatiya Nagrik Suraksha Samhita, the state government shall prepare and notify a witness protection scheme for the state with the view to ensure the protection of the witnesses. Okay? Withdrawal from the prosecution. There is a minor change. Under section 321 of the Code of Criminal Procedure, a prosecution may withdraw only on the request by the public prosecutor with the consent of the court. But as per the BNSS, no court shall allow to such withdrawal without giving an opportunity of being heard to the victim. It means audio alteram partem. There must be an opportunity of being heard by the given by the court. Compoundable offenses relating there shall be the no compounding of the offenses relating to the offense of the defamation against the higher dignitaries like the President of India, Vice President, Government of the State, Administrator of the Union Territories, Minister of the respective. Now, it can only be done with the permission of the court. And lastly, we are moving clarification with respect to the limitation period. With the limitation period and the computing of the decay, there is two changes. BNSS now clarifies for the computing the period of the limitation, the relevant date shall be date of filing the complaint under section 3223. It means when there is a limitation period, when there is a question relating to the limitation, when the complaint has been made, the date on which the complaint has been made, it is a question. Second, every high court shall have to exercise its superintendence power over the court of session. In conclusion, we have removed all the difficulties made by the colonial laws, that is the Code of Criminal Procedure. And now we have our law, that is the Bharatiya Nagrik Suraksha Samhita, which is being detailed and in the exhaustive manner has been drafted by the Parliament. Thank you so much. Any question? Thank you.
सर ये क्लास कब से चल रही है सर सीआरपीसी की?